When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
So why didn't Donna Adelson testify? We think it is a combination of three factors. Number one, there were a lot of surprises at Donna's trial of things that the state was able to do that the defense did not anticipate, including the adoptive admissions issue, and also certain pieces of evidence that apparently the defense wasn't aware of or didn't pay attention to that the state was able to introduce, and which would be problematic on a cross-examination when she wasn't prepared ahead of time, such as the issue of the 2023 and the 2014 calendars. Next, Donna Adelson watched herself how her own witnesses were crushed on cross-examination. And finally, Donna Adelson's own performance at a prior hearing, her bond hearing, when she was being cross-examined by Sarah Dugan. She didn't do well, in our opinion. So in this video, we will show you Donna being questioned about her decision whether or not she would testify. We'll also read to you the portion that happened the next day on a sidebar. And finally, we'll show you Donna being cross-examined at that bond hearing a few months ago. Here we go.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Miss Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
the issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed. So we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client, but that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent. Please check with the jurors. Let them know that we will get started momentarily. Mr. Zellman, Ms. Fulford, Mrs. Adelson, the extra time that you have been provided, that has come to a conclusion. We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record.
This is a sidebar, something that none of us got to watch. So this is Judge Everett. In researching some matters last night in anticipation of moving into closing today, I did want to confirm with the defense that the defendant is not asking to testify. Mr. Zellman. We talked to her for a somewhat lengthy period of time last night over the phone while we were preparing. She informed Miss Fulford and my paralegal they had taken her off speakerphone at that point, that she felt secure in her decision. If Your Honor would like to have Mrs. Adelson come to the bench, I could have her, the court. Just have the bailiff bring her over here to the sidebar. Mr. Zellman, yes, sir. The court. Mrs. Adelson, before we move into instruction on the law and the closing arguments this morning, I once again wanted to confirm with you that you are firm in your decision that you are choosing not to testify. Donna Adelson. Yes, Your Honor, I am. The court. You are absolutely firm about this decision? The defendant, Donna. Yes, I am. The court. Is there anything further that you need to speak with your two attorneys about on this matter? Donna. I would like a few minutes to talk to them. Yes, if I could. The court. As to this particular decision or some other matter? Donna. As to this particular decision. The court. On this, I will provide a few moments. After this, we do need to resume timely. Yesterday, when the court made reference to contempt, this concern has continued to occur and also not returning from the conferrals. We need to resume court. So, as he explained in that footnote earlier, this comment was about them taking way too long, like about the attorneys not not complying with the timing issues. So if you need to speak to your attorneys now concerning whether you wish to testify, I will allow you to do so. I'm going to give you 10 minutes to accomplish this. When 10 minutes is up, we do need to move on. Ms. Kappelman, Judge, is it your intent to go right into instructions and closing at the conclusion of the 10 minutes? The court, that would be my intent. Ms. Kappelman, I would request 30 minutes because I need some more time to get my closing act together. So maybe that can give a little more time for the defense to do what they need to do as well. both parties need to share their closing PowerPoints and demonstratives with each other too. The court. Okay, we'll take it 30 minutes then. The reason why I'm bringing this issue to the party's attention is only because I believe the appellate cases of the state make clear prior to instructions and closing a request to reopen the case or for the defendant to testify. The exercise of the fundamental right leans towards allowing this to occur. I'm giving her this last opportunity to confirm with counsel and make this decision. Ms. Fulford, may I say something, Your Honor? After the state is done with their closing, we're going to need a break for time to set up our stuff. The court, that's fine. Will any recordings be used as part of the closing today? Ms. Fulford, yes. Ms. Dugan, may I ask for one more thing? Is it the court's intent to read the stipulation prior to jury instructions? The court, yes, because that will be a part of the evidence in the case. Okay, now here's another sidebar with the defendant present. Turning the other matter that previously came up during the sidebar, Mrs. Adelson, you remain under oath as to whether you wish to exercise your right to testify in this trial. Have you made a decision considering this? Donna, I have made a decision. The court, what is that decision? Donna, I'm not going to testify. Judge Everett, you're firm on this decision? You are firm on your decision? Donna, I am. Judge Everett, very well. I will make no further inquiry unless the state or the defense seeks for the court to do so at this point. And I guess what he means by that is, like, should he go through the whole colloquy about the rights and all the stuff? And neither party requested for the judge to revisit the entire issue with Donna right there. That's what he means. So the court, the colloquy on this subject matter is united through the multiple discussions that occurred the previous day of trial on this day as well. Okay, so yeah, that's what he's saying, and then I understand what he means. So what he means is that he did a full colloquy with Donna in the trial on the previous day. So the previous day, that's when he asked her. First, they were saying, no, we need more time, so on and so forth. And then they discussed, and then they didn't come back on time. Eventually, they come back. And then the judge did a full inquiry with Donna about whether she was going to testify. And in the end, she says she's not going to testify. So then we go overnight, because then they decided that the jury instructions and closing arguments would happen the next day. So she had this extra night to rethink it. They discussed it some more. Her defense attorney, Jackie Fulford, and Zellman's paralegal were talking to Donna. She thought about it some more, and she still decided not to testify. Then the next morning comes in. The judge had done some research, said, look, I'm going to give you, because you kind of hinted at the fact that you needed more time, and you didn't have enough time. I'm telling you, if you guys want to reopen the defense case and have her testify, I'll allow it to happen. Okay? Just gotta ask. So Zellman says, okay, well, we talked to her about it and she doesn't want to. And the judge was even extra careful. He says, okay, well, let's bring her in here. Let's ask her some questions about it. So they did a limited inquiry with her, just about whether she had reconsidered, had thought about it some more, and whether she had a firm decision not to testify. And she responded, I'm not going to testify, and that she was firm. And then she asked for an additional time. The judge gave her 10 minutes at first, but then because the prosecution wanted a little more time to prepare their closing, she got an extra 30 minutes to think about it. Then she comes back. Judge asks her about it. She's firm on her decision.
Nothing further at this time, Your Honor.
Cross-examination.
Ms. Nielsen.
Good morning.
So there in the room with you, during this call was, you said your, one of your attorneys, Susan Brotman, your husband, and then also Susan Brotman's husband.
Yes, that's correct.
Okay. And he was not your attorney.
He was not.
Your attorney.
No, he's not an attorney.
Okay. You were informed at the beginning of that call. This is the one on November 7th that recorded you while they were all in the room. You were informed that you were being recorded if you accepted that call.
Yes.
Okay. And that if you do not want to be on that recorded call, that you needed to hang up the call. Is that right?
Are you saying, does the recording say
Right. If you do not want to accept that recorded call, you should hang up.
if you do not? Yeah, no, I accepted the recorded call.
Okay. And you typically do hang up your calls, you said, after
I mean, I think I
your
did,
calls
yeah.
with Charlie Adelson when he was in custody. All right. But this particular call that day, evidently you did not properly hang up, right?
Evidently.
Okay. And have you ever forgotten to press the button on a call before?
I mean, it may have happened. I don't know.
Sure. Has your phone pocket dialed people before?
Has it what?
Pocket dialed people before? When you've been out of custody.
Pocket dialed?
Right.
I don't know what you mean.
Like if your phone is in your pocket or in your purse and it accidentally calls someone you didn't mean it to.
I mean, that could have happened, sure.
Okay. And you also could have not pressed the button on your cell phone to end a call before, right?
It's possible.
Okay. It's not quite as big of a deal as it used to be when you would actually have to hang up the phone.
Right.
Right. Okay. That's all. Thank you.
I don't have anything further.
Stephen, cross-examination.
Yes, sir. All right, so the incident in the shower, after you let the inmate know that you did not like what she was doing by telling her to stop, did she ever try that again?
No.
And that inmate's no longer, or you didn't disclose the name of that inmate, but you did tell the investigator that that inmate is no longer in jail with you, right?
She's no longer there. She left shortly after that.
Okay. As far as the arm twist incident from October of 2024, you said you reported that in February of 2025.
Yes.
Okay. And you wouldn't give the name, you said you wouldn't give the name of her to the investigator either. Okay.
No.
But you do know that if you would give her name, that instead of you being separated from the pod, she could be separated from you and you could be back with the general population.
Yeah, but she's not the only one that could hurt me. That's why I wouldn't do it. She had a half a dozen girls that came up to me.
Was there ever any physical violence by her or anyone she's friends with after that October
No.
24 incident?
No, that was it. That's it.
And by being in solitary confinement, does it give you an opportunity to have a quieter space where you can prepare for trial?
Well, I guess it would be a quiet space if I could get some sleep and I would be able to concentrate on what I'm supposed to do. Yes, that would be helpful.
Do you also get in-person visits with your attorney in jail?
I do.
Okay, and when that happens, are you in a room alone with him or her or both?
Yes.
Okay.
Yes.
And y'all are able to have conversations then that are private?
Yes.
For the sciatic nerve in December of 2024, were you offered a Solumedrol steroid injection for that pain that you declined?
I am going to object to the use of the medical records by the state based on a prior objection.
Stephen, do you have an ability to show that these records were not a part of what was obtained by Investigator Newland that is still disputed?
No, these are part of what was obtained by Investigator Newland. But my understanding is that the defense would have opened the door to this by asking her about all of these times she was seen by medical staff and what basically was not done for her.
As to that, I will permit the witness to answer. You may answer the statement.
Could you ask me one more time?
Yes, ma'am. For the sciatic pain, that radiates down your right leg, were you offered a solumedrol, a steroid injection, and then after that, a Medrol, so a steroid dose pack that you declined until you were able to speak with your physician?
No, I told her that in the past I had gotten a steroid injection in my spine, and she said, we don't do that. I could offer you, and it was a Medrol dose pack, I think.
A solumedrol
I can offer
injection?
you that, but we don't do that. And having had sciatica twice in my lifetime, I know what's been done each time, and I know that worked. And so she said, we can't do that. We don't offer that. You would need to see a specialist for that.
Okay. I'm going to show you this page. I'm looking at the encounter from December 13th, 2024 at 3:22 p.m. What does it say? Offered patient a solumedrol injection, and then starting tomorrow, a Medrol dose pack. Patient requests to decline until she can speak with her physician.
I don't know what a solumedrol injection, but she told me they don't give steroidal injections in the spine. She says we don't do that. And I don't recall her offering an injection. I do remember she said I could give you other medication. But I've been there. I've done that. I know what happens with sciatica, and I know what needs to be done. That's not going to be the answer.
For your arm and shoulder pain, isn't it true that you reported you had mild pain in your left arm and shoulder?
No, I heard that gentleman say that before. I couldn't believe it. I told her that I had severe burning pain down the outer part of my arm. I never used the word mild pain. So I don't know where they got that from, but that's not what I said.
Okay. I'm going to show you the encounter from February 3rd, 2025 at 2:29 p.m. Under musculoskeletal, does it say positive for left upper extremity limited ROM range of motion, comma, mild pain?
That's what it says, but that's not what I said. No way is that pain mild.
So that's just what the doctor would have written down, but you're saying that's not what you told
I
the
ne-
doctor?
I did, had that been given to me and I read it and I had to sign it, I would say I never said this. But I'm telling you, I never said mild pain.
Okay.
It's shooting hot pain down my arm.
For that injury, you did have an X-ray, and they did go over that X-ray with you and let you know that there was no fracture or
There
dislocation.
was no fracture. That's what she told me. I didn't think it was a fracture.
Or dislocation of your shoulder or arm.
No, there's just pain.
And they also went over your chest X-ray results with you to let you know that your chest X-ray appeared clear.
Yes.
Okay. You ultimately received the Band-Aid and Neosporin for the cut on your elbow.
Yes, I got that on Saturday. When did I get that? On Monday.
Okay, so within a day or two of the cut occurring.
Yes.
And you said that if you are given a bond, you will reside in Tallahassee, you will follow court orders. But when you were afraid of being arrested right after Charlie Adelson's trial, isn't it true that you hoped that you could get to the airport before you were arrested?
I wasn't afraid of being arrested.
What were you trying to get to the airport in time for? In that jail
My
cell?
husband and I were literally shocked and traumatized at what had happened to Charlie. And he said, we need to just get some peace. We need to catch our breath. We're going to go away somewhere. And I thought it was a good idea because I couldn't think straight. I really couldn't think straight. I was so upset, and so was he. And it was his idea. He said, sweetheart, let's go. Just get away. We're going to just get away somewhere so we can have some time to think.
Okay, so your testimony is that you weren't trying to go to Vietnam because you wouldn't be able to be extradited from there.
So my husband actually had said, we've been to Vietnam before. with friends. We were on vacation, and it really was like a place of peace. And so he said, if we go to a non-extradition country, then if the law enforcement decided that they wanted to arrest you or me, whatever, both, he said, we won't be sitting in a foreign prison waiting months to go back. We can buy a ticket and we can go home. And my understanding was that I could go home and I could turn myself in if that's what they wanted.
Okay. But you were hoping to make it out of America in time before you were arrested, right?
I wanted to get away. He wanted to get away. That's what we wanted to do. And we spoke to our attorneys. I asked them. They said there's no pending. We purposely called them to make sure it was legal to do it. And they said there's no, what were their words? There's no pending charges and there's no warrants. So you want to go. And so I thought you ask your attorneys and they tell you that. I'm going.
But Dan did tell you, as you say in the jail call, that knowing what they're thinking up there, I don't know if you'll make it out in time. I really don't. But that he said you might, or you might get to the airport and they'll stop you. It could happen.
That's what he said.
Right. So you went to the airport knowing that it could happen. They could stop you at the airport. You could end up being arrested.
Yeah, that's what Dan said.
Right. And when you were looking at places to go those couple of days after Charlie Adelson's trial, you were specifically looking, though, for countries that did not have extradition with the U.S.
For the reason I just told you.
Right. And the reason that you're saying that you were looking for countries with no extradition was so that you could get back faster in order to be arrested in the U.S.
No, that's not what I said. It's because, I don't know, maybe we watch too much TV or too many movies, but I've seen movies where people are stuck in like third world prisons and waiting and waiting and waiting. And my feeling was, this is not what we want to happen. If the state says they want us to come back, we'll buy a ticket. We'll come back on our own terms. We don't have to be sitting in a jail somewhere. We'll come back home and turn ourselves in.
Couldn't you have done that no matter what country you went to?
No.
No?
You
couldn't have found out that you had a warrant for your arrest and come back if there was an extradition
Well,
law?
not if they would. I'm not in law enforcement, but it appears that they would notify law enforcement in that country and then they could hold you in a jail for God knows how long. And I didn't want that to happen. So he said, well, that's why we'll do it this way, honey. That way, if they do notify us, so we get a phone call from our attorney or from law enforcement, then we'll buy a ticket, we'll go home.
Okay.
And so it would have been on our terms. That was the point. That was the reason that he thought that was a good idea.
And your
You
testimony.
continue, Ms. Dugan. We are over time. If you please can get to your most pertinent questions.
Yes, sir. I guess your testimony ultimately, though, is that you were not trying to go to a country with no extradition because you were trying to avoid being held accountable for this charge. That's your testimony?
I didn't do this.
Okay.
Being held accountable for this is not what happened.
Being arrested for this case.
Being arrested?
Right. That was not what you were trying to avoid by trying to go to a non-extradition country.
We were trying to get our heads on straight and just breathe.
That's all that happened.
Thank you for watching today's deep dive. If you found this case interesting or have any thoughts, feel free to leave a comment below. Remember, this community thrives on smart and respectful discussion. Don't forget to like, subscribe, and hit the bell to stay on track with our new case videos. We cover new details, court hearings, interviews, interrogations, and more. This is Maya with Deep Dive True Crime and Mentor Lawyer Justice Network, and I'll see you all in the next video.